Greetings. I welcome you to another video in our series. This time around, we are looking at the admissibility of different types of evidence in South African courts. By popular demand, this video comes to you, and it is looking at how different types of evidence are admitted in courts. In the South African courts, what considerations are made, and among the different types of evidence, we have hearsay, we have opinion, we have similar facts, we have previous consistent statements, we have character evidence, and we have admissions. Well, we have different other types of evidence, but for the time being, we will confine ourselves to the ones that are listed there for you. Remember that if in order to get the best out of this series, you must follow the links that are provided. You must write an email, you must join our chat groups so that you can be able to participate in an ever-growing community. And in future, most of these videos will be released only to those who are registered. So make sure that when there's an opportunity for you to register, you do so that you do not miss out on the videos that are coming up. Thank you very much again for being part of this. Remember to like the video, to subscribe to the channel, and remember to also hit that notification button so that when new videos come up, you are notified instantly. And last but not least, may you share with your friends and with your community so that everybody can get to benefit from these videos. Thank you very much. Certainly, at the end of the video series, you should be able to define each of those different types of evidence: your similar fact evidence, your character evidence, your previous consistent statements, your hearsay, your opinion, your admissions, and your confessions. You must also be able to identify and explain the circumstances in which each of those types of evidence are applied, and you must also be able to discuss the restrictions and the factors in terms of which they are excluded, because as you will find out, each of those types of evidence are applied in courts subject to qualifications. So it is those qualifications that you must seek to understand. As a rule of the thumb, let us recap on Section 210 of the Criminal Procedure Act 51 of 1977, which talks about relevant evidence, or rather irrelevant evidence, being inadmissible. It says no evidence as to any fact or matter or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point or fact at issue in criminal proceedings. So relevance here is the measure, it's the criteria. Whatever evidence is discussed or is being presented in court, in order for the court to admit it, the court must be satisfied that that evidence is relevant to prove or disprove whatever material, whatever questions, whatever facts, whatever arguments may be there to consider. You must also understand, of course, that the application of our evidence is still subject to the residual rules of English law, as applicable up to 30th of May 1961. So our sources of evidence will not only be our own constitution and statutes here in South Africa, but you may have to look at principles of English law, but that is covered in another video. Let's not spend too much of our time on that. As a point of departure, we go straight to look at similar fact evidence. What is similar fact evidence? We will look at it as we proceed into the next slide. So talking of similar fact evidence, the basic rule of admissibility remains central. Relevance is the principle and it is paramount. We've already mentioned that. So this evidence must be logically relevant to the facts in issue, otherwise it will not be admissible. In other words, the court will not consider it. It will not accept it as a valid evidence upon which it can base its verdict. So when potential prejudice outweighs the value of the evidence, you find that it must be excluded, even if it's logically relevant. So you find that, similar fact may sometimes help the court to reach, to solve the questions before it. But then sometimes it has that prejudicial effect. So even though in some instances it may be, logically related to the facts in issue, the acts that the court is trying, it may be so prejudicial to the other party to the extent that its exclusion may be justified. So there are two questions that one must ask and answer. The questions are, what is similar fact? And then the next question is, under what circumstances is it admissible? Or rather, what requirements must be met in order for this evidence to be admitted? Well, in simple terms, one could say similar fact evidence is evidence about a fact which is similar to a fact in issue, even though the fact about which the evidence is being led is not an issue before the court. It sounds like a mouthful, but maybe let's try and simplify it in this manner. Sometimes you have an issue before the court. We have facts before the court, and then, as you shall see in the examples that we have there, somebody then brings up evidence which is not exactly about the issues before the court, but somebody brings in a fact that is similar to the facts in issue, and then tries to use those to justify a certain inference, and trying to persuade the court to reach a certain conclusion based on the similar facts being presented. Consider, for instance, somebody who has in the past been convicted of theft, and so this time around he or she is brought before the court and is being tried maybe on a charge of theft. And then the prosecution now tries to bring in evidence to show that previously this accused person has been convicted of theft, as if to suggest that because the person was once convicted of theft, therefore even the theft that has happened now is attributable to the person. As you shall see, this kind of logic and reasoning is very problematic, because then it seeks to try the accused not on the basis of the facts before the court, but then it enjoins the court to now start speculating that if the accused has previously been, found to be in contravention of a certain law, then it goes without saying that even now he has done so or she has done so. So it's like trying the accused and trying to convict them, not on the basis of what they've done, but on the basis of their character, on the basis of their disposition, on the basis of what they have done in history, which sounds a little bit unfair if one could look at it. There are many other instances where similar fact evidence does get to be applied or to be led by some people, some parties before the courts. Let's look at some of them. So our examples of similar fact, I've already spoken about the accused facing a charge of shoplifting, and when prosecution wants to bring evidence that he has previously been convicted of shoplifting. So the previous case of shoplifting is not before the court, but prosecution wants to use it to prove that the accused has a character or disposition towards theft and shoplifting. The state adduces, in another instance, the state adduces evidence that X, who has been convicted of serial killing in the past, is actually the perpetrator in the case being considered by the courts. So it's using this inference that because a certain pattern of killing is associated with X, therefore even in this current scenario, X must be convicted. That's similar fact. Or in some instances, the accused may lead evidence to discredit the police by demonstrating that the police do use some force, inappropriate force to interrogate the suspects and so on and so forth. This case, in fact, this incident happened in the case of Goshok versus Roseau. It's one of those cases that you may want to check out to find out how the accused may sometimes use this similar fact evidence, maybe for himself, to his own advantage. Take note that the purpose of the similar fact evidence in most occasions is to demonstrate that the accused, who has displayed a certain pattern, is responsible for the issues before the court. And the risk of prejudice is certainly high if such evidence were to be admitted. For instance, if admitted, it would justify a conclusion that the accused is the type of person who will commit a specific crime and has therefore committed it in the particular instance before the court. As I said earlier, it's like seeking to convict the accused on the basis of their character rather than on the basis of the issues, or rather the conduct, culpable conduct that they may have committed. So, looking at the admissibility of similar fact evidence, the requirements are as follows. There must be a logical connection between the similar fact and the fact in issue. In other words, there must be a nexus between the two facts being juxtaposed. The similar fact being used as evidence must have probative value. In other words, it must be of sufficient value to assist or enable the court to draw logical inferences upon which a verdict may be reached. So the two requirements are the nexus, or the connection between the similar fact and the issues before the court, as well as the probative value, to say if such evidence is admissible, will it assist the court? If it's prejudicial, then that prejudice is actually weighed against the benefit that is said to be derived. So if you find that the probative value of that evidence is negligible as compared to the benefit that is sought to be derived, then its inclusion rather will be a matter not entertained. So, looking at the historical development of the similar fact evidence in South African law, one may have to look at the case of Makin versus Attorney General for South Wales in 1894, which was decided by the British Privy Council. Now, why do we talk about the Privy Council of Britain when we are in South Africa? Well, you will agree with me if you have read around these issues that South Africa's law of evidence developed from English law principles. Remember that English law principles of evidence were applicable in South Africa until the 30th of May 1961, when South Africa became a republic. So, which then means that all the principles of law developed and applied in terms of English law until that period are actually applicable to South Africa, except those that maybe an act of parliament has actually been elected to repeal them. So the South Wales was also part of the British Empire, and I guess it still is. And so had its matters referred to the Privy Council as the appellate body, which then means that whatever decisions were made by the Privy Council in connection with issues or cases in South Wales, they would also be applicable to South Africa in terms of that colonial relationship between South Africa and Britain. So that's very, very important to take note of. So in this Makin versus Attorney General for Wales case, this is how the court reasoned. I'm going to try and read it as it is. It says, it is undoubtedly not competent for the prosecution to choose evidence tending to show that the accused has been guilty of a criminal acts other than those covered in the indictment, for the purpose of leading to the conclusion that the accused is the person likely from criminal conduct of character to have committed the offense for which he is being tried. On the other hand, the mere fact that the evidence adduced tends to show the commission of other crimes does not render it inadmissible if it is relevant to an issue before the court or the jury, and it may be so relevant if it bears upon the question whether acts alleged to constitute the crime charged in the indictment were designed or accidental, or to rebut a defense which would otherwise be open to the accused. So we will look at this a little bit further, but there are two things there that come up. The first one, of course, being that it is unethical and unsound legally to conclude that because Mr. X has in the past committed a certain act, therefore he or she is guilty of the current one. And secondly, it says that the mere fact that evidence shows the commission of other crimes does not then render it inadmissible. If it is in the interest of justice, then it will be admitted, even if it does show that X may have committed other offenses. These are the lessons that we have already alluded to in the foregoing. Maybe the question is, what are the two important points that you can take from the dictum in Makin versus Attorney General? Well, it is inappropriate for one to reason that because Mr. X has in the past committed a second act, he has committed it in the case at hand. It raises the implication that he is of a bad character, and it is for his character that he stands for convicted. I think we have belabored this point. It highlights the fact that similar facts may be admitted in instances to prove that the act alleged was not accidental but was designed, premeditated, planned, and contemplated by the accused. You see, that's very, very important to take note of. So it may actually be an indication that the action or the facts upon which the accused is being charged actually show that X had planned and premeditated this thing well in advance. It may be worth your while and your time to do a reading on some of these cases that we have there. For instance, we have our DPP versus Boardman, 1975. We've got our Harris versus the Director of Prosecutions, 1952. And then we have got our S versus D, 1991. And our R versus Solomons in 1959. So if you find these cases they may shed light on some of the most applicable principles when it comes to similar fact evidence. I'll just maybe beneath we'll look at Director of Public Prosecutions versus Boardman, and then we'll also look at R versus Solomon. Then we will conclude from there. Now, in the Director of Public Prosecutions versus Boardman in 1975, you see this was a Privy Council decision having persuasive value, of course, in South Africa, because by that time South Africa was no longer part of the British Empire. So having severed the ties in 1961 on the 30th of May, it is those residual rules that we still experience in the Criminal Procedure Act 51 of 1977, as well as the Civil Proceedings Evidence Act 25 of 1965. They are still very, very relevant. But the House of Lords reasoned that other misconduct may only be adduced if it displays a striking similarity to the misconduct charged. So in other words, there must be a striking similarity. It's not just a casual similarity where you think maybe the facts before the court and the other facts being adduced seem like they have some remote similarity. It must be very striking similarity. That is very, very important. So the House of Lords declared that in determining the admissibility of similar fact evidence, a judge had only to consider whether the probative force of the other misconduct was sufficiently great to make it just to admit the evidence, notwithstanding that it is prejudicial to the accused, intending to show that he was guilty of another crime. So, in other words, the similar fact being adduced must be so important and so relevant to the issue, so logically connected to the issues being tried, that the prejudice of exposing the fact that the accused has committed another offense previously is actually outweighed by the benefit that the leading of this evidence will yield. So that's a very interesting and important test there to consider. Now, the R versus Solomon's case is another case, as I have already alluded in the foregoing. Evidence may be inadmissible at one stage of the trial, but may be admissible at another stage. So in the R versus Solomon case, evidence that was found to be inadmissible at the early stages of the trial was later found to be admissible. In this case, you find that the prosecution tried to prove that the accused had used a knife to stab other people before the commission of the act for which he was being charged in the courts. And so the prosecution was leading that evidence. And so when prosecution tried to introduce that evidence, the court actually did not admit it, reasoning that it was prejudicial for the court, for the prosecution to lead that evidence to prove that the accused had previously tried to stab other people. But later on, in the course of the trial, when the accused raised a defense disputing that he had a knife that evening, the evening in question when the act was conducted in terms of which he was being charged, it then became relevant to show that no, he had previously had a knife. So the proof now of a knife could only be laid by, as the prosecution was showing that the accused had previously had a knife, it then had to draw in the issues of, similar fact evidence. So whilst the evidence was inadmissible at the early stages of the trial, it became relevant later on at the end of the trial. I think the principles in Makin versus the Attorney General of the South Wales do come into relevance in this case. Well, talking about the similar fact evidence, you will find that the principles that we have discussed in the foregoing have actually been very instrumental, and those are the very kind of issues, principles that one has to take note of. And it is important to consider and understand that there is no closed list of instances in which similar fact evidence may be admitted. And we are saying in all instances it must be noted that the criterion of relevance is the deciding element whether to admit or dismiss similar fact. Secondly, the potential for prejudice must not outweigh the evidentiary value that is sought to be obtained by leading this kind of evidence. So, in short, similar evidence may be admitted, but subject to caution, the caution being that we cannot infer that because X has done certain things in the past, so therefore he has actually done them now. So it is, admitted circumspectly, but at the same time, if it is logically relevant and the degree of prejudice against the litigants is negligible, then it will be admitted. So far, we have spoken about similar fact, and as I said, this is a series. There are other, we have these other types of evidence to consider. So we pack it here for now, and then the next video is coming to you shortly. So keep your eyes open. Thank you very much.